Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today we are going to discuss a case law, decided case law by the Honorable Supreme Court of India, two judges bench, giving benefit of doubt to the accused in a murder case of 1985. In the present scenario, we are not seeing any acquittals by the apex court. Normally, all of them, they are convincing, they are getting convinced and they are confirming the sentence. It's a peculiar case where the benefit of doubt was given to the accused, that too in a case of 30-40 years, 1985. Briefly, we will discuss the important points on which the Honorable Supreme Court of India laid thrust for giving the benefit of doubt. This you can read the case as Munalal versus State of Uttar Pradesh. Munalal versus State of Uttar Pradesh in criminal appeal number 490 by 2017, decided on 24th January 2023 by two judges bench, Honorable Justice S. Ravindra Bhatt and Deepankar Datta. You can see the citation in Live Law SC page number 60, Live Law 2023. Right. So going to the facts of the case, we know that on 5th September or 5/9/1985, around 10 a.m. in a village called as Fatehpur Burza in Uttar Pradesh. So there was an attack on Narayana. He is the deceased person, Narayana, who is the father of Ram Vilas. So he was attacked and done to death by using the so-called bullets. He was shot at. He was shot by the other assailant groups, that is Munalal and others. 3 persons have been booked and others they have been acquitted. So, basing on the report of this Ram Vilas, an FIR was registered in Fatehpur Burju against that is Shinlal, Munalal and Bablu Ram. Right. Immediately, as per the procedure established by Section 154 and also 160, 161, the police followed. The IO reached the spot at 1:30 p.m. on that particular day, and he said to have been recovered a bullet also. Actually, it was recovered from the hip of the dead body. From the hip of it was oozing, the blood was oozing like anything. Anyway, he collected it, but the point is you could not recover the weapon from which it was fired. So the investigation revealed that it is a counterblast to another death. Previously, this Shinlal's father was also attacked by the deceased in this case, and it's a counter murder. But this murder has taken place 10 years back, not now. So the motive portion is not fixedly established. So anyway, the lower court convicted the accused person because basing on the I say quantity, there so many witnesses they have come, they have deposed, and even the High Court in Allahabad, they also confirmed the sentence. Ultimately, the matter came to the Supreme Court. Here we have to know the important points. Supreme Court acquitted, give benefit on the 3 following points. Number 1, PW1, the main prosecution witness was examined by the police and his statement was recorded after 24 days with a delay. So the recording of the statement of the witness under section 160 CRPC or 161, we call them as 161 statements. It was done after 24 hours. That means with heavy delay. That means there may be a chance of that is padding, adding. So more than the other facts, more than the natural facts, they might have added. So that is the first benefit, first doubt the Supreme Court got. Second point, the investigating officer reached the spot and he recovered a bullet from the oozing from the hip of the dead body, but the weapon was not recovered. No weapon was recovered. What is the use of seizing the bullet? And third, non-obtaining of the ballistic report. So this is more important. Ballistic report should say that this is the bullet which caused the injury. This is the bullet which came from the particular weapon. So from a distance, from so and so distance, ballistic expert or so or firearms expert, we call them generally, they will give all the details. But this was not obtained. Of course, the IO was under the opinion that since the weapon is not used, what is the use of getting the ballistic expert? So these three mistakes in the investigation, they made the Supreme Court believe that there is some doubt. You all know, whenever there is a doubt, the doubt should go toward the accused. Same thing happened, the case ended acquittal. And another point here you have to memorize, Section 34 of the Indian Evidence Act, which says it is the quality evidence, it is not the quantity. It is not the quantities. Let 100 people come and say parrot-like version, but if one witness says, yes, this is the thing happened, yes, the court can rely on his a single independent witness. That is the quality evidence we want, but not the quantity. Section 134 of the Indian Evidence Act says, please remember, evidence to be weighed but not counted. Evidence to be weighed but not counted. In other words, quality but not the quantity. Even in a murder case, number of witnesses not necessary. The persons who tell the fact, even if they are few number, it is enough. So the testimony was can normally we call it as wholly reliable, wholly not reliable, or wholly unreliable, partly reliable, partly unreliable, like that. But here and another most important crucial point, non-examination of the IO. Non-examination of the IO. So many things happened. So no doubt, although the defective investigation should not lead to acquittal, the other point, all these points are coupled together, definitely they are giving benefit out to the accused, as a result of which the conviction was set aside by the Honorable Supreme Court of India. So very good case law, particularly for the people who are practicing in murder case, other things. So please remember the case law and you can cite the same whenever required. With this, I am concluding. Thank you very much.